proliferated, and can't the judiciary itself take?
My experience has been, I was Chief Justice in Punjab for a while, and my interaction and see my experience of, let us say, 22 years in the judiciary is that there is a bureaucratic approach to allocation of funds. It's a bureaucratic approach in the sense that if you ask them, give me 500 crores, they will say, what for?
Yeah.
If you say, no, I will spend on something which I like, they will say, no, this is not the way we do it. So, the bureaucracy wants you to project a demand supported by data. They will say, all right, you will say, I want 100 crores for establishing a judicial academy. They will ask you, how will it help? You will then have to explain, yes, a judicial academy will train
So many judges.
Yeah. The judges will be trained, their performance will improve by, let us say, 15%. If it improves by 15%, the areas will be cleared, you see earlier, and so on. So, logically, you tell them that this is the way it is going to contribute to speedier justice, enhancing or promoting access to justice. But as such, if you say, no, there is a denial at the threshold, I don't think there is any such approach. I think we are now, at least I'm talking of India, money has not been a major issue. In the 13th Finance Commission, they set apart something like 5,000 crores for the judiciary. We could spend only 2,000 crores or so. We were unable to spend the balance. The balance lapsed.
So
the 14th Finance Commission has set apart 10,000 crores, 9,900 and some crores, around 10,000 crores have been set apart. Now, those 10,000 crores, earlier the government of India used to give through the Supreme Court and the High Courts. The change now is that devolution will take place to the states. The money will go to the states. And one of the issues that we are discussing in the ensuing Chief Justice's Conference and Chief Minister's Conference is that if states are getting 10,000 crores to be spent over a period of 5 years for the 14th Finance Commission, on an average it will be 2,000 crores every year. We must be ready. Judiciary must be ready with plans to ensure that 2,000 crores is actually spent. If you do not have plans, if Chief Justices are lethargic, if they do not have any idea as to where this money has to be spent, if they remain busy with second appeals and first appeals and you see the ordinary run-of-the-mill work, then this will suffer, it will lapse again. So, one of the issues that we are raising and where we are sensitizing our Chief Justices is to have a clear-cut plan before them so that whatever their share out of this 2,000 crores, maybe 500 crores goes to Uttar Pradesh, 100 crores goes to, you see, some smaller state. They must have their priorities laid out. They must say, well, you have our share and this is 200 crores, this is where we want to spend. And they must be ready and projects must be properly conceived so that the money can be spent. You do not have as such any problem, if you ask me till now, most of the states except 2 states which are a little conservative, where there is a problem, and that is West Bengal and Kerala, where the priorities differ. So otherwise, generally, I think people have been always very cooperative.
Let me share my experience. I had the opportunity to take part in the Asia Pacific Justice Conference that was held in Singapore. And that time, a paper was presented by one of the justices of the High Court of Australia. Justice Han had presented a paper on administratively independent judiciary. You could share many of his experiences in his own perspective, based on your own experience from Australia. And I had the occasion to make a comment on that paper. Then these problems that we are talking about here are of permanent nature and it touches upon everybody's experience all over. That is one common experience. But it seems to me that the experience of the developed systems are different from ours. They are better resources, and the allocation of the resources in the better developed systems are higher than that happened in our part of the world. And they seem to have little problem than we are confronted with. Then I had a proposal that perhaps we need to have some points to make, to be clarified as part of our negotiation point with the government. It is not that the judiciary cannot speak to the government, to the parliament. If it is required, then we have to speak to the parliament because the post will be controlled by the parliament. And there is a practice in America, in Europe, the courts will be visiting to the parliament. The registrar will make a budgetary proposal, and the ESC will have the occasion to defend the budgetary proposal in the House of Parliament, the committee. America is very clear that the proposal would be defended by the president. President will make a budgetary proposal, and before the budget will be presented, then there will be a conference with the justices, and there will be a separate budget for the judiciary. The president will have to make a separate budget. And before that happens, then there will be some significant negotiation between the presidential office and the judiciary. And the presidential office can make a suggestion to bring out some changes in the estimate. But if the judiciary insists that the amount that are expected should be maintained, then they can just add their suggestion, but they cannot change the estimate that are moved from the judiciary. So that is how they have been doing. My point here is that when we talk about the administratively independent judiciary, there are a couple of things that needs to be clarified. Number one is that the judiciary should be given away the power of rulemaking power itself, meaning that the minimum process should not be decided upon by the judiciary or by the legislature or the executive. It should be decided upon by the judiciary itself. The recruitment of the human resource shall have to be decided upon by the judiciary itself. Because if we create certain positions and the executive or through the budgetary estimate, the legislature come across saying that this much position cannot be created, but this and that, then that is one way of controlling the judiciary. So in terms of the creation of the positions and in the appointment process, the judiciary need to have a final say. That is one situation. And in terms of the apportionment of the money through the budget, in that case, there should be a very clear-cut dialogue between the judiciary and the finance minister or maybe the legislature itself. Meaning that the judiciary will have to prepare its own budget based on its own experiences and expectations. Because the judiciary knows what job is left with them. So they know better than any other institution. So that part will be expressed through the estimate. And there could be some negotiation because the government also will be having some scarcity of the resource problem. So they may not fulfill all our expectations. There could be some reason. But if that is the case, then the priorities may get changed. So certain amount of negotiation can continue between the judiciary and the exchequer. Here we have developed a practice in the recent time that before the finance minister presents the budget in the House of Parliament, he will be visiting the Chief Justice. He will be calling on the Chief Justice, he will be sharing his experiences, and that will be the occasion to share the expectation of the judiciary and to tell about the limitation of the government. So, based on my experience, whenever the Chief Justice have met the Finance Minister, I have, most of the time, I have the occasion to participate in that negotiation process. And with the meetings held between the Chief Justice and the Finance Minister, there has been some significant rise in terms of the allocation of the resources. That is one practice we have developed. There has been some skepticism whether or not the judiciary can speak to the minister or the legislature. My point has always been that we are not talking about the subjudice matter. We are not trying to get ourselves influenced by whatever expression the executive would like to make will not be influenced in impact. The way the concern will be shown by them in terms of our allocation of resources, that should not be a reason to influence us. We are independent by our heart. When independence is in our heart, then nobody in the world can influence us. That is one very strong commitment that we need to have from within. And then my point here is that certain amount of money should be allocated based on our experiences and expectations. In our case, the Planning Commission also comes across. Before the budget reaches out to the Finance Ministry, Planning Commission will have to approve the program that we may like to implement. So Planning Commission also helps, and the Finance Ministry will be coming across. And once they finalize, then I said earlier that the Finance Minister will have to speak to the Chief Justice before he finalizes the budget. The another problem is that once the budgetary limit is clarified, but as Chief Justice Thakur said, there could be significant, money that would be allocated for the judiciary, but whether we will have the capacity to spend it. That is another problem. But it is not always true that simply because of our capacity, lack of capacity, we don't spend money. It is largely because of the reason that the money that would be allocated and divided into many years and will not be given the freedom to move from one year to another, because the autonomy doesn't lie with us. For the reallocation of the budget that are specified for 1 year, 1 year is enough, or more than enough, but the other year is inadequate. We may like to transfer this budget from 1 year to another, but then only certain percentage of the total budget. For that, then we may have some autonomy. But if that is the significant amount that need to be transferred from 1 year to another, then they will not allow us. And for that reason, on the one hand, we may have our programs incompleted for lack of money. On the other hand, the budget will be remaining not spent, unutilized. For the simple reason that we didn't have the autonomy to move from 1 year to another. So that has been one very big reason. And the understanding of the Chief Justices that I have found is that it is a matter of the financial autonomy of the judiciary. Once the money, a chunk of money is allocated for the judiciary, then the judiciary, the Chief Justice maybe, Chief Justice and the Registrar should be having the autonomy to decide on what head the budget will be distributed, for what court, how much money, in what manner the budget will be spent, and if there is a requirement for the change from 1 year to another, then that autonomy should be given away to the judiciary itself. So that is a very significant authority for ensuring our financial autonomy. I have been told that the Chief Justice of Singapore, they have introduced the idea of the multi-year budget. That means for 5 years. They will introduce the budget for 5 years. That means if they spend 20% of the money in the first year, then they can further plan for the remaining 4 years. And within that, then they can spend maybe 50% in the first year and the rest of the money for the coming 5 years. It is the freedom that will be given. It helps in the real planning process to bring out the judicial reforms and to be able to be effective. So there are certain ideas that have worked well in different jurisdictions, but in this part of the world, the bureaucratic approach that controls the administrative and the financial autonomy of the judiciary, that has been a hindering fact. And here I would like to make a point that if it is possible, that we may call upon through our resolution that the funding for the judiciary should be increased, because in some jurisdictions I have seen in some constitution there has already been specified that certain amount of money will be spent on the judiciary. For instance, though this is a small country, in Costa Rica, the constitution says that 8% of their national budget will be allocated for the judiciary. There are certain countries where it says 1% around will be allocated for the judiciary. In the UK, you can see more than 4% of their national budget is being spent on the judiciary. So there are certain percentages that may vary from one jurisdiction to another, but we can say that at least some minimum. Here we have been asking to the government that 1% of the budget should be allocated for the judiciary. At one point of time, the government of Nepal has agreed, theoretically agreed, that we will be committed to assure that you will be having 1% of the budget of the national budget. But so far, in terms of the practice concerned, it has been largely around 0.6%. Largely around 0.6%, never reaching out to 1%. And we have been dreaming of to reach out to that point. So that has been one point. So my point here is that whether we may suggest that the investment on judiciary may be increased, keeping in view of the requirement of the judiciary to function as an independent institution and to ensure the better access to justice by the people. So that could be one reason, and through that we may call upon further that the disbursement, the autonomy to decide on in what year how much money can be spent and how it can be transferred from one year to another. That should be entirely left with the Chief Justices. So whether that, in a way, and I don't think that it should be a problem, because it has been a problem that has been recognized elsewhere, and it has been expressed. In the Singapore country, in fact, they had brought out a working group of the Chief Justices, headed by the Chief Justice of Hong Kong, South Africa, Philippines, Guam, including myself. The working group, and the task is yet not completed, but the working group has been created. So just to share my experience with this, encountering with this problem. So
however much we discuss or say, finally it's with the executive, the treasury.
This is a dialogic process.
Now what we do is, if we need 500 million or 500, we inflate it and say 600, then they will give 500. That is how we are doing it.
Ours is a very, very complex one. Possibly Pakistan is also facing the similar problem.
Same problem. Yeah.
The problem is from the higher judiciary, Supreme Court, it is the Supreme Court gets the budget. And previous Chief Justices could not spend the money, so whenever you can't spend money, then next year allocation will be less. Now, I assume the office, I spend all the money, then I wanted money, you give me money, they provide transfer. But so far lower judiciary is concerned, it is with the
They decide.
India, lower judiciary is a state subject. State judiciary is a state subject. Central government has nothing to do with it. Central government may only for specific projects support the states. For instance, computerization. Computerization is a very huge project. So central government provided some grant so that the entire country judiciary gets computerized. But otherwise, there is no direct link between judiciary in the state and the union government. Union government says it is a state subject. That is why you will find in that country, states like Haryana have the finest infrastructure. Air conditioned, you see, civil judges' courts with power backup and all, beautiful rooms, beautiful, you see, bar rooms and everything, beautiful complexes. I must have myself inaugurated 12 such amazing complexes because they are cash rich, they have money, their resources are very, you see, very good. But in other places, you will not find the same kind. Like for instance, Bihar and maybe UP also, the allocation for judicial infrastructure is relatively less. Now, as you said, Chief Justice, about the power of reappropriation, we call it reappropriation. For instance, if you get in Supreme Court of Nepal, you get 10 crores. In that 10 crores, maybe you have for hospitality 50 lakhs. And for stationery, you have 1 crore. Now, you feel that hospitality money has been finished. You want to shift from stationery to hospitality. Your power to shift is limited by rules. That appropriation, power of appropriation is always regulated by the state. So it is granted, but it is granted in a very, very conservative way. You can shift, let us say, 5 lakhs from this place to that place, not beyond 5 lakhs. So that is a matter, I think, which needs to be taken up with the government, so that the appropriation part is, this is a problem everywhere. Each high court will have its own budget, And within the budget, the power of reappropriation is also given. But that is one part. We are talking about the capital investment. But capital investment like new courts, as you mentioned, recruitment and vacancies, creation of vacancies, that is not in the hands of judiciary, even in India. We can't create vacancies. As Chief Justice, I can create a vacancy. The power to do that is there, provided the post is already one which is sanctioned. For instance, if I want 100 more peons, 100 more clerks, 100 more deputy registrars, I can do that. But if I were to, let us say, create the post of a barber, I can't, because it is not there. In any case, the recruitment in states, judicial officers, and creation of more vacancies is always with the state. The Public Service Commission recruits. Because of some problems in some states, High Court has taken over. With the consent of the government, the recruitment process is with the High Court because of some problems with the Public Service Commission. But number of courts and number of officers, you see, that is left to them. So what we did, in Imtiaz Hussain, there's a judgment at which I am a party, we declared access to justice as a fundamental right. And we said access to justice must be speedy. You must get quick justice. Quick justice depends upon the number of judges that are available. And if the state is to drag its feet for creation of new vacancies, you are denying access to justice, because if you provide only one judge where 10 are required, the justice is being denied because one judge cannot do the work of 10 judges. So based on that view, we told the Law Commission, please tell us, what is the optimum that a judge can do? How much work can a judge do? We wanted that if we fix a yardstick, that a judge of different kinds of work that is before him, a civil suit, a criminal case, some other applications, miscellaneous together, his optimum handling capacity is, let us say, 3,000 cases. Then we would say that between 3 and 5, and the number of cases goes above 3 and below 5, the state must create another court. We wanted to, you see, connect it with the burden. An earlier judgment of the Supreme Court had taken a slightly different view. The court had said, in America, you have 150 judges per million population. And therefore, the court declared that in India, over a period of 5 years, you raise the number of judges so as to be 50 per million. Now that led to a very anomalous situation. There is population, but there is no work. Like for instance in Jharkhand, you have population, but there is not much of work. So if you are to create proportionate to the population, you will create so many more courts, but there will be no work. Whereas in Kerala, where there is literacy, there is awareness, there is population, but also a lot of work. So somewhere it would work, somewhere it would not work. That judge population ratio would not work. The new exercise that we have started, and that has also reached now a particular stage, the Law Commission has submitted a report. National Court Management Systems Committee is now looking into it. We are trying to evolve a method where we will, by a judicial order, perhaps lay down a benchmark that if the number of cases in a court go beyond the handling capacity of that court, then the state is under an obligation to sanction another post. But that we will do by a judicial order. There is no way by, you see, any other administrative arrangement, you will be given the right to create a post. They will not concede to that. They will, you see, resist it. The only remedy in such situations is if you can, you see, evolve that jurisprudence and right, the access to justice being a fundamental right, and access to justice being dependent on number of judges, and number of judges being a matter which is to be decided by a particular method, a formula, then you can say, well, this is a formula that is evolved. Because of this formula, you must have 2 more judges here, and to create those posts, force them to create the posts. Then they will create, otherwise they will not. Otherwise the choice is entirely with the executive.
And the Crown, we've been very fortunate, we've put it in the Judicial Service Act, so it's with us.
Oh, very good.
We have a Judicial Service Council, and
Which
and
decides about the
yes,
number of
yes.
vacancies you will require.
Yes.
Very good.
and we are from a very small jurisdiction. The case also, the benchmark is just 300 cases per year. Then we create an additional.
Another additional post. That's very good.
That's good.
But
That's
there are
why
in India, you have places where 5,000 cases with one judge. He doesn't know today, he fixes a date 3 months hence. There were situations where for, you see, check bounce cases, 138 of the Negotiable Instruments Act, for check bounce cases, the complainant statement has to be recorded before process can be issued to the accused. 6 months date is given. You come 6 months hence for your statement to be recorded, so that someone can go to the accused person. Such was the flood of litigation. In fact, we have been in India also telling them that when you bring a new legislation, you must at the same time work on the impact of that legislation on judicial system. Because if you are making a new law, you must also anticipate how much litigation will be generated by the new law, and whether the judicial system is going to come under stress because of your new law, and therefore you provide for that contingency, because you are making a new law, because of which the litigation is going to come, and you are not providing sufficient space to the judicial system. So there are multi-dimensional issues. I don't know whether we can really pass a resolution in a matter like this, which has multi-phase.
The problem is, before taking resolution, that is what I was pointing out. What the lower judiciary, the fund is allocated to judge, exclusively the domain of the lower judiciary. So, suppose in a court, district court, there are 15 courts. The capacity is only 10 courts, 10 judges. 5 judges are because after the independence of our judiciary. Pakistan in 1973, but we, by judicial pronouncement, we separated the judiciary with the lower judiciary, magistracy, special magistracy. The magistracy was under the executive. Now, we separated the magistracy and the entire judiciary under the garb of Supreme Court. Now the financial control is with the executive. Now about the magistracy, when it was separated from the government's report, it appears 7,500 magistrates. Now they will not allocate fund. They will not create any code.